Attorney General of India from the M. Laxmikant 8th edition, Indian Polity. So, the Constitution Article 76 has provided for the office of Attorney General for India. He is the highest law officer in the country. Appointment and terms. The Attorney General is appointed by the President. He must be a person who is qualified to be appointed as a judge of Supreme Court. In other words, he must be a citizen of India and must have been a judge of some high court for 5 years or an advocate of some high courts for 10 years or an eminent jurist in the opinion of the President. The term of office of Attorney General is not fixed by the Constitution. Further, the Constitution does not contain the procedure and grounds for his removal. He holds office during the pleasure of the President. This means that he may be removed by the President at any time. He may also quit office by submitting resignation to the President. Conventionally, he resigns when the government Council of Ministers resigns or is replaced, as he is appointed on its advice. The remuneration of the Attorney General is not fixed by the Constitution. He receives such remuneration as the President may determine. Duties and functions of the Attorney General. As the Chief Law Officer of the Government of India, the duties of the Attorney General include the following. First, to give advice to the Government of India upon such legal matters which are referred to him by the President. Second, to perform such other duties of legal character that are assigned to him by the President. Third, to discharge the function conferred on him by the Constitution of any other law. The President has assigned the following duties to the Attorney General. First, to appear on behalf of the Government of India in all cases in the Supreme Court in which the Government of India is concerned. Second, to represent the Government of India in any reference made by the President to the Supreme Court under Article 143 of the Constitution. Third, to appear when required by the Government of India in any High Court in any case in which the Government of India is concerned. Rights and limitations of Attorney General. In the performance of his official duties, the Attorney General has the right of audience in all courts in the territory of India. Further, he has the right to speak and to take part in the proceedings of both the houses of the Parliament or their joint sittings and any committee of the Parliament of which he may be named a member, but without a right to vote. He also enjoys all the privileges and immunities that are available to a member of the Parliament. In order to avoid any complication and conflict of duty, the following limitations are placed on the Attorney General. First, he should not advise or hold a brief against the Government of India. Second, he should not advise or hold a brief in cases in which he is called upon to advise or appear for the Government of India. Third, he should not defend accused person in criminal prosecutions without the permission of the Government of India. Fourth, he should not accept appointment as a director in any company or corporation without the permission of the Government of India. Fifth, he should not advise any ministry or department of Government of India or any statutory organization or any public sector undertaking unless the proposal or reference in the regard is received through the Ministry of Law and Justice, Department of Legal Affairs. However, the Attorney General is not a full-time counsel for the government. He does not fall in the category of government servants. Further, he is not debarred from private legal practice. Solicitor General of India. In addition to Attorney General, there are other law officers of Government of India. They are the Solicitor General of India and Additional Solicitor General of India. They assist the Attorney General in the fulfillment of his official responsibilities. It should be noted here that only the office of the Attorney General is created by the Constitution. In other words, Article 76 does not mention about the Solicitor General and Additional Solicitor General. The Attorney General is not a member of the Central Cabinet. There is a separate law minister in the Central Cabinet to look after the legal matters at the government level. Articles related to Attorney Generals of India at a glance. Article 76 related to Attorney General of India. Article 88 related to rights of Attorney General as respects the House of Parliament and its committees. Article 105 related to powers, privileges